We're the moms who ask the questions, digging deep, no second guessing. From the school run to the crime scene, truth and chaos, we're the dream team. Bad Kids Club, yeah, we ride or die. Sad eyes sharp and our standards high, brought together by FKR. Now we're taking truth real far, and we're just getting started. Talk time with Amy, Boston, and Kelly, spilling facts that hit your belly. Partners in crime, fueled by conviction. Moms on a mission with sharp intuition. Talk time, we're calling out lies with caffeine, chaos, and side-eyed vibes. It's raw, it's real, it's how we vent. Leaning close, let the reckoning commence. This is Talk Time with Amy, Boston, and Kelly, where the tea is hot and the truth cuts.
Oh, I'm muted. Hello, family. Gotta find myself. Let's fucking go. Who's ready to watch some Lally and Proctor get destroyed by Rosemary Scapicchio? Scapicchio? Is that how you say it? I hope I said it wrong. I don't want to make people mad. Don't want to make people upset because I said it wrong. But what do you mean? It was on. I saw it. At least it played on here. Go, Rosemary, go, Rosemary, go, Rosemary, go. Yeah, it played. Did anybody else hear the opening, or am I losing my mind? I want to make sure it's not me or you. We'll figure it out. Smada, hi. I'm so excited you're here. You did hear it. Okay, Mark heard it, so then it has to be your earbuds, Miss Amy. I miss you. My besties. Yesterday was Mark's birthday, you guys. So wish him a happy birthday. And then tomorrow is Knick-Knack's birthday. So let's make sure everybody wishes our Knick-Knack a happy birthday too. Where else, baby? Right here with us, because you love us. Yes, 20s. I said, welcome to the 40s, where your cake is on fire because you have so many candles on top. So, bang, bang, bang. 40, what? Oh, we got the Hyde Park girls in the house. So I have the Zoom running in the background. And stop it. Let's see. I know. Who would have thought? Two of our favorite peeps have birthdays within days of each other in here. Declan totally outed me on Omar, the Tilted Lawyer. And I was not happy because I was trying to say I was 35. And he's like, you're 48. And I'm like, thanks, Declan. And everyone started laughing. They were like, you just got outed. So 48, that's me. I'm here, 48. I'm proud of it. Although what I'm not proud of is I got the invitation to my 30th class reunion. I almost vomited. How the heck if I graduated 30 years ago? What? How does that happen? What? She's gonna take You know what? I am gonna go. I'm gonna go. I'm making my best friend Christy go. She doesn't want to go because she's not happy with how she looks. She doesn't want people to look at her and be like, look at Christy. And I'm like, you look beautiful. I love you, Amy. Thank you. And so it's gonna be me and Steve, Christy and her boyfriend Mike, and then our other friend Kelly, who Kelly and I went to, we were, I'd say close friends. We're not like that, like besties, like Christy and I, because Christy and I have been together since second grade, like two peas in a pod. Look who's here! She made it. Woo-woo. She made it. But so yeah, we were two peas in a pod, and they better start this meeting. And so, but our friend Kelly and her boyfriend Gerald are going, and we're going to go as the three couples together and hang out and be our other classmates. We've lost a few, which is that's the scary part when you start losing people you went to high school with. So it's not fun. But you passed on all your reunions. That's true. If I like you, you're still in my life. I will say, honestly, at my 10-year class reunion, I laughed after I left because I lived in California at the time. And hey, Rosie. Oh, it's your daughter's birthday. Happy birthday today. I left and went to on my way home. I was telling my ex-husband at the time, my husband at the time, he said that he's like, how did it feel? And I was like, well, I mean, it was great, except for the fact that I got voted most changed in the reunion. And I'm like, so was I really that dorky in high school? And that all of a sudden people are like, look at Kelly, she doesn't even look alike. I was like, that's weird. So like the whole class, literally there, it was like a landslide. There was maybe two other people in the thing. They just kept calling my name when they read them out. And now we didn't have a lot of people in our graduating class, so it's like I think we had like 150 people in our graduating class. And so it wasn't like we were a big school. You can butt into any conversation you want to, Danny. This is a Bad Kids Club. We butt in all the time. Oh, we got some. Court is up. Let me join the audio here. And mute. Whoop, whoop, I did it. I got the right one. We got Jem's forehead, guys. Who's excited for Jem's forehead? Woo! Jem's forehead. I am like in a good mood this morning. I had a dream that I told I was divorcing my husband. I told him this morning. I said, we're getting divorced. And he was like, what? What did I do? And I was like, no, I just dreamed it. I mean, I dreamed it because I needed you to be there for me and you weren't there for me. So I told you divorce time. He's like, great. Another day of you being mad at me because of your dream. I'm like, do you expect anything different? Anything different? So they filed a motion last night trying to get him, Natalie, we love you too, baby. I think they filed a motion late last night or right at the end of the night, of course, because that's what they do. Let's file it right before, trying to where he doesn't have to testify. But I believe, I don't know. I think Rosemary's gonna throw a fit about that. I don't think Scapicchio is going to allow that to happen. She's going to let it go because he's already started his testimony. Why finish it? Why not finish it? So, I love looking at Jim's head. Let's see who's all on. We got Broken Bakers on. We got them on. We've got Crystal's iPhone, Misty's iPhone, and myself. So not many people are logged in yet. Surprised. Surprise, surprise. Trying to use dude, I was first in line, guys. I logged in at like 8 o'clock to make sure, because I was like, it better be the right Zoom, because it was the same one from last time. You can't remember which Law 2 lawyer said that they were trying to use the reason.
Concession, please be seated.
That's docket number 21CR320, the Commonwealth versus Miles King. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Michael McGee for the Commonwealth.
Okay,
Good morning, Your Honor. Jennifer Hickman on behalf of the Commonwealth.
thank you.
Good morning, Your Honor. Rosemary Scapicchio on behalf of Mr. King.
Thank you.
Good morning, Your Honor. Nicole Scapicchio on behalf of Mr. King.
All right,
Good afternoon.
Mr. King.
Good morning, Your Honor. Julie Smith down for Mr. King.
Okay.
Have a seat. And Your Honor, I represent Adam Lally, Pat Hanley.
Your name again?
Pat Hanley.
Okay, thank you.
Thank you.
Okay, I think we first need to deal with the scheduling stuff. I got a number of motions to continue the hearing that's scheduled for noon. I know Ms. Scapicchio indicated to the clerk she objects to the continuance.
Yes, Judge, my client, Mr. Johnson, is in the lockup. If we're gonna, I didn't know we were gonna deal with it right now. If we are,
Okay.
can he be brought in?
I think, given the situation we've got, I mean, I don't want to put this over until noon to deal with this.
Good, Your Honor.
I understand that the Commonwealth has a meeting set up for this afternoon, or?
Our counsel informed me that the U.S. Attorney's Office would speak with us at 4 o'clock today.
Okay.
I did have a meeting or a phone call with them last week where I explained procedurally where we were with the variety of different cases, as well as the concerns expressed by you, Your Honor, and Judge Frenier. So they were aware of our requests, the various courts' requests, statements that defense counsel had made in court, and they were aware that there was a hearing that was scheduled last week in front of Judge Frenier and of today's hearing at noon. And we reached out to them last Friday in anticipation of the hearing before Judge Frenier, and we're told that we could have a call today at 4 o'clock. So I apologize that I don't have more information at noon today, but it just doesn't make sense to me to appear at noon and ask for more time.
Right. And that's why, to the extent we were able to cancel some of the folks from being brought in, we tried to do that yesterday.
Thank you.
I understand Mr. Johnson is here, and I apologize for him being brought in, but it seems to me that we ought to move this to a date that is viable for everybody next week.
So, Judge, can I just be heard very briefly?
You may.
Thank you. So I had a conversation with Michael Sullivan, who represents the Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney Lamacchia. My biggest concern is whether or not it's been communicated to the U.S. Attorney's Office and or the federal judge that you and Judge Frenier and everybody else are looking for this February 2024 order. When I had that conversation with Assistant United States Attorney Lamacchia, he didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of, is that being discussed amongst the things that need to get resolved? Because this court has made it clear that you're not inclined to make a decision on my request for discovery until we get that order. And I just want to make sure we're not waiting until next week, and then all of a sudden someone says, now we need the order. So to the extent
Well,
that,
look, I would like to see the February order.
And I
Okay.
conveyed that to them.
But I also have to deal with the issue of whether, regardless of what the order says, whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders, but we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together. I think.
Judge, I appreciate that 100%. My concern is if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that. So
Yes.
And I invited you the last time to seek to intervene or to do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes.
Okay. So we'll put, let me just see, we will put.
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right. We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th, on the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Thank you,
Okay.
Your Honor.
And
Right.
is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately for the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Now, with respect to the King matter, we're just dealing with the issue of the late disclosure, and
May I be heard, Your Honor?
sure.
At the close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, would be prejudicial to him. I have not heard of one document since these have been provided in April and May. And to that end, I'd ask the court to order that right now. I think that this has gone on. This is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently, and then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of a two-phased process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor I believe was sitting on your desk as Monday morning. It was a third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the file that I got, I think, from Ms. Scapicchio's office. I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a table. It's the third. If you look at the manila folder that's underneath that, there, in a rubber band, it's in your hands right now.
Oh, in here, okay, this one.
That, yes. The third doc.
Okay.
That is what I prepared with the assistance of ADA Hickman.
Okay.
Which specifically describes what, if anything, is minorly different. That was provided to council on Thursday last week. We met we got a teleconference on Friday, and council was working on their own lists.
Okay.
So to answer your question, no, there was no agreements as of now. We endeavored to meet earlier and understand from my pleading what council disagreed with, but that was not reached. The Commonwealth has provided you as best we can what has been previously provided.
Okay.
If there's any subtle differences, we can supplement that at a later date, but at this point, I know ADA Hickman has worked very hard to go through the material.
Attorney Scapicchio?
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have 2 dueling charts, huh? So you have the Commonwealth chart and your chart.
Yes.
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get together and work, figure out a...
I tried to.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on Friday...
Do I have a list of the items which are new or which you claim to be new, and that I can then cross-reference against the Commonwealth list, which you say are prejudicial or are exculpatory and you're behind the 8 ball because of the late disclosure, notwithstanding the continuance?
Yes, Your Honor.
Okay, where will I find that?
So where we find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right. So you need more time to get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. So I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say, this is where we are and this is where we stand. But if we don't have everything, and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say, this is,
well,
now
as an initial crack, I wanted a list of what was new and what was prejudicial in the 2 notices as of when the motion to dismiss was filed.
Yes.
That's what I think we were shooting for. We understood that some new stuff had been produced after that.
Yes.
I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time what was new as of the time the motion to dismiss was filed.
So Judge, what I did with the new information is I put it in chart 2 as just a description of it. I cross-referenced it to a base stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes.
You were referring to lots of stuff which is not in the record.
Correct.
Right? We admitted in the last hearing exactly one document.
Yes.
Right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit, and then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient, and then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thanks.
Oh, I'm sorry.
All right, so I've been handed 3 charts. Chart 1, chart 2, and chart 3. You're moving their admission?
Yes, Your Honor.
Okay, any objection, at least for the record here?
No objection.
Okay, so these will be marked as, unfortunately, exhibits 2, 3, and 4, because we already have an exhibit 1.
And may I admit the Commonwealth's exhibit? That's the chart.
This is the Commonwealth exhibit.
Yes.
Any problem with this?
No, Your Honor.
Okay, so this
They're
will be
right.
exhibit 5.
Thank you, Your Honor.
Thank you. All right, how do I deal with these charts? How do I read them? They look like you're talking past each other to some extent, that they're not, so if I look on exhibit 2, which is the defense chart number 1, discovery address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone, draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth is, in their pleadings, are indicating that we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does it show? Document description is received by King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized. So the Commonwealth is claiming, so for the first 2, Judge, if I can just show you, for the first 2, the Commonwealth is claiming that they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was...
No, just slow down. I want to understand what Exhibit 2 shows.
So Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us.
You're
from
quoting something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW. I'm sorry, you're quoting what?
We're quoting what the Commonwealth named these documents in their opposition, Judge. That's what the Commonwealth named these documents, to try to convince the court that we already had them. The search warrant stuff down there. The 2.
Okay, and you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the Bates stamps in the ones that we did. So if you look down to the second column, we do have Bates stamps. There were some things that were given.
Second column?
Second part of the chart. We were able to provide Bates
Second
stamps.
chart? Or the...
No, just where it says notice 4925.
All right, so how do I compare what you have to what the Commonwealth has provided me, I need you to be on the same page. I need you to go through every single document that was produced that you base your motion to dismiss on. Every single one. You have to address every single one, okay? And you have to make a chart saying, this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right. So I need all of it.
Okay.
Okay. So I understand the scope of the problem. And then I can analyze the question of prejudice. After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think it would be a much more productive use of time than putting Mr. Lally back on the stand or anybody else. Because there are real constraints on the court's ability to provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And so you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm sorry about that, but I think we need to do this in a logical order.
Thank you, Your Honor.
I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2 if you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th. But the 12th would not be for evidence. It would be for an explanation of the analysis that you've done on all the various documents that were apparently produced late.
I don't know where we'll get it. I mean, we could let the clerks know if we could.
I'm happy to report back at 2, Judge, if that's what you wanted to do.
Yeah. I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think, frankly, I should see you on the 12th, because if you're not done by 12 or whenever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event, and it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new. And then I need to hear from defense counsel, document by document, as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
We're none.
We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order, and I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
My understanding on the last date, Your Honor, is we put it down for noon because Attorney Moynihan would be here, and today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you had read the order and felt that you could make a decision.
Frankly, Your Honor, I didn't notice we were addressing that today.
Would you like to be here on the 12th also?
would need to check, but if I could be available on the 12th, but that would be a better day than today.
Okay.
If you want to
Do you have your calendar?
Sorry.
Do you have your calendar?
Just call my office.
Okay. Let's put it on for the 12th. Call your office. If for some reason you're unavailable, let me know. I'll get back on the bench and we'll set another time.
Is that 2 o'clock, Your Honor?
It would be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So if you decide you want to be heard today, I'll hear you on it.
I prefer the 12th. I can let the clerk know if I'm available at 2. I believe I can be
Okay, all right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk know and I'll hear you now. Okay? Okay. Anything else we can do today? Thank you. Thank you.
All right.
What? I guess. All right. Are we going downstairs to your office? Or are we doing this here? Okay, great. Thank you. Myself.
Hello. Okay, so let's going to clock out of the Zoom. Well, that was a nothing burger, of course. So I will start the Zoom back at 1:45. Sorry, Liam came back out, you guys. So I'll start the Zoom at 1:45 and see what happens if they get their papers, whatever, done. But it sounds like everything. Am I on mute? Okay, no, I'm not on mute. I'm like, am I on mute? It sounds like everything is going to be moved to the 12th. So that would be next week, which would mean they would do this on the 12th, which might not even be an evidentiary hearing. It's going to be going over the papers if they don't do it today. Yeah, they told them to go downstairs for the next 3 hours and work on a chart together because they're conflicting. And they're conflicting because Rosemary can't do anything without the discovery from the Commonwealth. And, you know, shocker, the Commonwealth doesn't want to give over discovery. So there's going to keep kicking the can, which really sucks because Miles King has sat in jail for 4 years. He's out on bail right now. They finally lowered his bail so that he could be out on bail. So at least he's not sitting in jail, but he should be in jail, honestly, because we know he did it. I mean, there's no it was supposed to be Mark. It was supposed to be them on the stand, but you know, Krupp decided that there was other things, and Lally put in his, Lally doesn't want to testify at all. He put in a motion last night to not testify. Let me see if I can find the motion real quick and we can read it. So, Liam, turn it down, please. Thank you. Where's Declan? We need Declan. Let's see. That's the Commonwealth versus March. Let me see if I can find it. Lally. William, turn it down, please. I don't see it in here. I just know that it says third party Michael Parker's motion to limit scope of appearance for the hearing, and then it says Commonwealth's motion to continue, and then witness's motion to limit scope of questioning of attorney under subpoena, which is Lally's. So they don't actually have the paperwork up yet. I don't see. Oh wait, there we go. I found it. Meredith to the rescue, guys. Let's see. Jacqueline, come get your brother's cup. He wants a drink. Your brother's cup. He wants a drink. Yeah, just for a little bit longer.
Oh, after, can you make my shells and mac and cheese?
For lunch, not at 9 o'clock in the morning. Okay, so this is Lally's motion to limit scope of questioning of attorney under subpoena. On May 28th, 2025, the defendant in this matter filed a motion to dismiss or in the alternative release on bail and continue the trial date given the voluminous late disclosed evidence. After that motion was filed, the parties jointly requested that the court continue to trial date and reduce the defendant's bail to $2,500 with conditions. After hearing, the court allowed the request for a continuance, but set the bail at $10,000. The defendant posted the cash bail on June 27. The court should suspend Lally's testimony unless and until the defense makes a preliminary showing that all three required prongs required for dismissal: egregious government misconduct, prejudice to the defendant's right to a fair trial, which is what they're working on now, and showing that the dismissal is the only remedy for the prejudice. The hearing on the motion, now addressing only a motion to dismiss since the trial date was continued and the defendant was released on bail, was scheduled July 21st. Assistant District Attorney Adam Lally was issued a subpoena by defense counsel to appear in the hearing in this matter, scheduled for July 21st at 9 a.m. He appeared and began testifying over his attorney's objections. At that court hearing, let's see, defendant and the Norfolk County's Attorney's Office. Let's see, is that the second one? Yeah. All right. The defendant and the Norfolk County's Attorney's Office to work together specifically identify the scope of discovery was disclosed late into the defense. The court also directed the defendant. This looks weird. Why is this not? Let me see. Yeah, that's right. All right. Says the court also directed counsel to the defendant to review the materials, identify specifically any exculpatory evidence that was displayed late to the defense. Liam, turn it down, please. Attorney Lally testified July 21st, and the hearing continued until August 5th, with the expectation to the parties would have narrowed scope of discovery at issue, and counsel for the defendants would have identified the claim to be exculpatory or prejudicial. Before Lally's testimony recommences in this matter, counsel for the defendant should comply with the court's directive and identify how the evidence at issue is exculpatory and how the defendant has been prejudiced, particularly given that he has been released on bail and the trial has been continued. Without the two requests for dismissal or requirements for dismissal under Commonwealth first subpoena, citing Commonwealth versus Edwards, the motion fails and testimony from Adam Lally becomes unnecessary. Should the court still wish to hear from Adam Lally, we, the undersigned counsel for him, respectfully suggest that the testimony should be strictly limited to the issue of whether his conduct constitutes egregious misconduct when in the light of 26 notices of discovery, providing unique discovery each time certainly does not. B, the Commonwealth v. subpoena issued by the appeals court last Thursday is on point and dispositive, where the defense has made the prima facie showing that the three prongs required for dismissal, and the court had already taken significant remedial action in the case. Last week, the appeals court issued a decision in the Commonwealth versus Trepania. This case is worth a close study. Like this case, it emanates. I can't talk. I'm not Englishing today. It emanates from the allegation of late disclosure of evidence that was ultimately disclosed. It says pinpoint citations are to the Lexis page numbers. A copy of the case is attached as Exhibit 1 for case reference. Liam, volume down. You hear me? So we are here. Okay. In that case, the trial court issued an order to produce the discovery, but included Liam. Sorry, guys. Liam's so loud. Liam, turn the volume down or I'm taking it away. Thank you. The appeals court was clear that dismissal of the charges as a sanction for a violation of mass criminal in the absence of the findings or irremediable harm was an abuse of the discretion. In the footnote 8, it's the decision, the appeals court acknowledged in 2025 amendments to Rule 14, including this to the sanctions provisions, but wrote, we discern no substantial changes in this language. Rather, we think it merely provides an illustrative list of sanctions to aid litigants and judges. A dismissal with prejudice under Rule 14 still requires a showing of irremediable harm. In order to warrant dismissal, there must be egregious prosecutorial misconduct and prejudice to the defendant's right to a fair trial, and dismissal must be necessary to cure the prejudice. Commonwealth v. Edwards, quoting Commonwealth v. Washington, where the defense has not made preliminary showings, all three components required under Commonwealth v. Trepina and Commonwealth v. Edwards, the case cannot be dismissed. The remedy of dismissal is only warranted when there is egregious government misconduct, prejudice to the defendant's right of fair trial, and showing the dismissal of the only remedy for the prejudice. In this case, should counsel for defendant fail to identify for the court how many of the documents at issue are exculpatory and therefore the late production prejudiced his rights to a fair trial, and where the counsel for the defendant failed to show how dismissal is necessary to cure the prejudice, given that the trial date has been continued and the defendant is released on bail, the defendant's motion can be denied without further testimony from Attorney Lally. In any event, Attorney Lally's testimony should be strictly limited to the issue of egregious government misconduct. The court will learn that Attorney Lally was diligent, well-meaning, and that his conduct aimed to conform with his obligations as a prosecutor. So, who believes that Lally was diligent, well-meaning, and that his conduct aimed to conform with his obligations as a prosecutor? Anybody? Raise your hand if you believe that. If you think that he's, done his job right, and he's done it in good faith. Do we believe that? Because I don't. I don't believe that. Diligent. They were so busy trying to frame Karen Reed, they didn't do their job when it came to Adam Lally or when it came to Miles King's case. And that man has been in jail since before Karen's trial, since before John passed away. It just makes no sense to me. Is Zepp in the house? Hey, Zepp, how are you? Yeah, the judge seemed kind of cranky today, but Krebs like that. When he was on Aiden's case, he was like that. It was obnoxious. So, let me see if I can find anything else in here. Like maybe, let's see.
Yep.
Let's see if I can find Proctor's. That was a waste of time. Do you guys want to? It's up to you. Do you guys want me to find the hearing from the last time when he testified and watch it again so we can be refreshed, or no? Because I think I have it up here. Let me see. Oh no, I don't see it. That's somebody else's. I don't know if I have his passive aggressiveness from the last hearing. Let's see. Let me see if I can find Proctor's. I'll search for Proctor's, okay? Let's see if we can do that. And then we'll go from there. I can look for it. Give me a minute to look for it. Let me see if I can find Proctor's motion. Let's see. That was a while ago. You know what I believe is out. Oh, I found Proctor's motion. So, Meredith to the rescue again. This is third party Michael Proctor's motion for clarification of court's memorandum and order date June 17th and for the protective order. Now comes Michael Proctor, a third party order and who is the subject of a subpoena that has been issued in the above referenced matter. Michael Proctor to appear at a hearing scheduled August 5th, 2025, who, by the way, just didn't show up and was on vacation, apparently. If that was me, I would be in jail, but, whatever. And who moves for clarification relative to the court's memorandum and order dated June 17th, 2025. Mr. Proctor also requests a protective order to be restrict disclosure of privileged information. After reviewing the order, Mr. Proctor requests the following. 1, clarify the dates of remedy that was granted in the order. The court allowed the defendant's motions to preserve and produce cell phone records of Proctor's personal cell phone as to the communications, including content, call durations, times, numbers involved of former state trooper Michael Proctor's personal cell phone. from the date of the charged murder, July 4th of 2022, to the date of indictments. Oh, I thought it was 2021, so I was wrong. Sorry, guys. To the date of indictments, December 12th, 2022. The order goes on to state that the Commonwealth shall promptly produce any other data from Proctor's personal cell phones that constitute investigative materials or is favorable within the meaning of the Mass Crime P14. The parties and Mr. Proctor have questioned the defined time frame as to whether this order is consistent with the previous paragraph and runs from the date of the charged murder, July 2022, to the date of indictments, December 12th, or whether the court intends another time frame. Furthermore, Proctor was ordered to preserve his cell phone and all data on his cell phone, to provide his personal cell phone to the Commonwealth, and to disclose the carrier for his personal cell phone with the Commonwealth. The parties and Mr. Proctor have questioned the defined time frame as to whether the order is consistent with the previous statement that the time of disclosure runs from the date of the charged murder, July 4th, 2022, to the date of indictment, or whether the court intends another time frame. Number 2, Mr. Proctor changed his phone and used his applications to delete content. Mr. Proctor changed his phone in February of 2024 and did not preserve his old phone. Mr. Proctor was not subject to a court order to preserve his old cell phone at the time he changed phones. Additionally, after Mr. Proctor activated his new phone in February of 2024, he also used an auto-delete feature that has deleted the contents of his phone every 30 days since activation. Seems to me like Meatball Morrissey told him all about that. Remember, because he was deleting his every 30 days. Therefore, regardless of the time frames for the court order to be clarified, it is unlikely that Mr. Proctor has any relevant information in his possession concerning the case. Moreover, Mr. Proctor has not been a detective in Norfolk County's Attorney's Office since July 1st, 2024. Under Mass Criminal P14.2, protective order must be ordered as follows. Upon a sufficient showing, the judge may at any time order the discovery or inspection be denied, restricted, or deferred, or make the order as is appropriate. The judge may alter the time requirements for Rules 14, 14.1, or 14.2. The judge may, for a cause shown, grant discovery to a defendant on the condition that the material be discovered be available only to counsel for the defendant. This provision does not alter the allocation of the burden of proof with regards to a matter at issue, including privilege. Attorney-client privilege. General rule of privilege: a client has the privilege to refuse to disclose and to prevent others from disclosing confidential communications made for the purpose of obtaining and providing professional legal services to the client as follows. 1, between the client or client's representative and the client's attorney and attorney's representative. 2, the client's attorney and the attorney's representative. 3, between the involved in joint defense. 4, between representatives of the client and between the client and the representative of the client. Or 5, among attorneys and the representatives representing the same client. Who may claim the privilege? The privilege may be claimed by the client's guardian or conservator, the personal representative of the deceased client, or the successor, trustee, or similar representative of a corporation, association, or other organization, whether or not in existence at the time of the privilege is claimed. The attorney and the attorney's representative at the time of the communication is presumed to have authority to claim the privilege. Pursuant to the court order, Mr. Proctor asserts his right of attorney-client privilege and moves this court to issue protective order instructing that any communications contained in his personal cell phone and information derived from his personal cell phone that are privileged between himself and his attorney be withheld from disclosure. The attorney-client privilege is the client's privilege to waive. Mr. Proctor and his attorneys have frequently communicated by text and email and exchanged documents that are subject to privilege. Given the text messages and emails are an acceptable form of communication between a lawyer and his client, and the legal documents are frequently held on such devices, it is reasonable for Mr. Proctor to assert and for the court to order that any such privileged communications be respected and withheld from disclosure. Plaintiffs must satisfy Mass Criminal P17A2 because plaintiffs seek production of records, privileged or non-privileged. Mr. Proctor, a non-party prior to trial, Commonwealth versus Lampron, Commonwealth versus Ogden, upon satisfying the requirements of Mass R Criminal P14, 17A and 2, and a non-party has produced records to the court. The protocol set forth in the Commonwealth versus Dwyer. Excuse you. You say excuse me.
Gary.
Not yet. Say excuse me.
Me.
Thank you. Jacqueline, will you please get him some more Gatorade?
Me.
Governs review and disclosure of presumptively privileged records by defense counsel. Spousal privilege pursuant to mass spousal privilege disqualification, parent-child disqualification. General rule is a spouse shall not be compelled to testify in the trial of an indictment, complaint, or other proceeding brought onto the spouse. Pursuant to the court order, Proctor asserts spousal privilege and moves this court to issue a protective order instructing that any communications contained on his personal cell phone or information derived from his personal cell phone that are privileged between him and his wife are withheld from disclosure. Given the text messages and the email, Declan, is an acceptable form of communication between husband and wife, it is reasonable for Mr. Proctor to request and for the court to order that any such privileged communications be respected and withheld from disclosure. Wherefore, because of formally stated reasons, Mr. Proctor requests the court to clarify and define the dates that he provides to preserve relevant information from his personal cell phone. Additionally, Mr. Proctor requests the court to issue protective order. Spousal privilege. So, and funny that, yeah, he gets rights to his phone. Sarah Dawn, hey baby girl. My Heather is here. I see you. Let's see. So yeah, it's funny. All of a sudden, he wants privileged communication and all his stuff under seal. They thank you. They steal everything. Everything. It's ridiculous. I'm gonna look and see on YouTube if I can find the court hearing. I know we have it, but I'm trying to find it from the actual hearing. Lally testifies. Let's see. That's. It seems everybody. Oh, it looks like they are. I found it. Look at this. So if you guys want to watch this, I'm happy to play it. Just as a refresher for everybody. Share screen.
Certain materials bait stamped in the notice of discovery 28. It's a little difficult for me to figure out whether this is entirely
lab reports, if they had access to fire department, run reports, been ADA Lynn Beelan.
Okay. And
You solemnly swear the evidence you give the court in the case now and hearing true the truth, the whole truth, nothing but the truth to help you God.
So this is not today.
good morning, Mr. Lally. In a loud, clear voice.
This is not the hearing from today. Today's hearing got continued. We're going to come on at like 1:45 and see what happens. Because they're supposed to possibly reconvene, I think, at 2. But if they said that they would let him know where they were at. So if not, then it's now the 12th. So, but this is the first hearing when Lally first testified. So I figured we could watch this as a refresher.
Could you please state your name, spelling your first and last name for the record?
Sure. Adam Lally, A-D-A-M, last name L-A-L-L-Y.
And what do you do for a living, Mr. Lally?
Assistant District Attorney with the Norfolk County District Attorney's Office.
And how long have you worked for the Norfolk County District Attorney's Office?
Since 2005.
20 years?
Yes, almost.
What did you do before you worked for the Norfolk County District Attorney's Office?
Started with the District Attorney's Office straight out of law school. Worked a couple warehouse jobs, things like that. I worked a few warehouse jobs, things like that during law school. Went to school at night.
Okay. And what school did you go to?
Suffolk.
Suffolk Law?
Yes.
And undergrad?
Undergrad, I went to the University of Southern California.
Okay. And what was your, well, at some point, how long were you in the office before you got assigned to the homicide squad? Oh, homicide unit, I'm sorry.
I'm not sure that it's an assignment to the homicide unit. I would say the first homicide that I had outside of the realm of motor vehicle homicide was probably 2015, somewhere in there.
Okay. And let me back up a little. What type of training did the Norfolk County District Attorney's Office offer you in order for you to be able to comply with Rule 14 discovery?
Objection. Sustained.
So when you started at the Norfolk County District Attorney's Office, you sat in district court?
Yes.
Okay. And how many district court cases would you say you tried?
I have no idea. A lot.
More than 100?
Probably.
Okay. And in all of those cases, were you able to comply with Rule 14 discovery and turn over the discovery that was required under Rule 14?
Objection. Sustained.
Let me ask you this. The hundreds of cases that you tried in district court, was there ever any allegation that you didn't turn over information?
Objection. Overruled.
No.
Okay. And then at some point you moved to Superior Court. When was that?
Began working on Superior Court cases probably in 2006, full-time assigned to Superior Court in 2012.
Okay. When you say full-time assigned to Superior Court, what does that mean?
So what that means is during the interim period from 2006 to 2012, I had cases in Superior Court, but I was primarily assigned to the District Court.
So you were trying cases in the Superior Court, but you were still trying cases in the District Court?
Correct. Actually, I still do that to this day.
You still try cases in the District Court as well?
I do.
Okay. But you said at sometime in 2012, you were assigned to the Superior Court. Does that mean you came here every day?
Correct.
Okay. And what type of cases were you assigned in 2012 when you became a Superior Court DA?
Variety, pretty much ran the whole gamut. Narcotics cases, sexual assault cases, child abuse cases, breaking and entering, armed robbery, whatever I was assigned, that's what I did.
How long after you got to the DA's office did you start trying what they call light felonies?
I don't understand the line of inquiry. Everybody who is in the DA's office is responsible for complying with Rule 14 and is expected to know the confines of Rule 14 and to comply with it. So the backstory here is not particularly useful. What I want to know is what ADA Lally did in this instance.
Understood, Judge. In any event, when were you assigned to the Miles King case? Brianna Gardner, I'm sorry.
Probably within a day or two.
A day or two of what?
Of the shooting and the murder occurring.
Okay. And how do you get assigned in the district attorney's office? Do they email you? Do they call you? How do they do that?
Objection. Overruled.
I received a call from the first assistant.
And who would that have been at the time?
At the time, that would have been ADA Lynn Beelan.
Okay. And did she tell you were assigned to this homicide case?
Yes.
And what does that mean to you, being assigned to a homicide case? What does that mean?
Well, I mean, at that point, it was an investigation. So as far as assisting with the investigation, should charges arise, handling prosecution from there out.
Okay. So once you get assigned to the Miles King, Brianna Gardner case, is there a policy within the Assistant District Attorney's Office in Norfolk County on how to gather information that's required under Rule 14?
Objection. Overruled.
A specific policy? Not that I'm aware of, no.
Okay. So there's no policy that you're aware of in the DA's office that that details how to gather information. Is that what you're saying?
Not that specific to that, no. Not that I know of.
So how did you gather information? How did you gather information in the King Gardner case that was required under Rule 14? What did you do?
Objection. Just specify what is. It's too vague. Overruled. Question is, what did you do?
So what I
think we can take it in chronological order. We'll start at the beginning and then we'll have follow-up questions.
Sure. So what I do is what I do in every case, depending on how many different departments are involved. In this case, there was a local department and state police involvement. So I would make appropriate requests for any and all information that they had, any information that, specifically I could outline or delineate as far as what I felt was relevant. And
stop right there. How would you make those requests?
Typically what I would do is write out a formal discovery request, submit the form to any involved departments, and communicate either via phone or email to whoever the relevant party was that I was requesting discovery from.
When you say discovery forms, what do you put on the form in this case for Gardner and King?
Initially, it would be for any and all police reports, any and all photographs, any and all information as to who was present, lab reports, if they had access to fire department run reports, any lab personnel that responded to the scene, so that I would have an idea as to whether or not there was testing that was going to be conducted or items had been recovered from the scene. Copies of any and all search warrants, including applications, affidavits, copy of the warrants, any returns.
And let me talk to you. Do you have a memory in this case of asking for all the information that you just told you normally ask? Did you do that in the Breonna Gardner and Miles King case? Did you ask for all of that information?
Yes, and just for clarity purposes, when I'm initially doing this, it's not the Miles King and Breonna Gardner case.
It's just an investigation.
Correct.
Okay.
Well, and more to that point, Ms. Gardner didn't become a focus of the investigation until later on.
Okay. So while you were investigating without a defendant being a suspect, at least not initially, you asked which departments for this information?
The State Police, Norfolk County Detective Unit, as well as the Milton Police.
I can't hear you. What's the last one?
Milton Police.
Milton Police. Okay, so you asked Milton Police, you asked the State Police. Who in Milton Police did you ask, and who in the State Police did you ask to send information?
The Milton Police would have been, at that time, Lieutenant Michael Collins. The State Police would have been Trooper Michael Proctor, as he was a case officer, and Lieutenant Brian Tully.
And so you have emails going to all three of them asking for all of the information that you just listed, which would be normal information that you'd ask in any case after a homicide. Is that right?
Yes.
And let's just take Mr. Proctor, Trooper Proctor, did he respond to you?
Yes.
And what did he provide you?
At varying...
No, to the extent he recalls, he can testify.
So at varying times, there were different productions of material, whether it was what was available at that time. So initially it would have been just whatever reports were available at that time. Later on would have been photographs, video.
So how often would you say you emailed or communicated with the State Police, and specifically Trooper Proctor or Trooper Tully, regarding discovery in this case?
I cannot tell you how many times via email, but I mean, it was a constant conversation, particularly throughout the grand jury process as far as discovery was concerned.
Okay, so when you say a constant process, was there a time period where you asked for stuff and you didn't get it, so you were re-asking for it, or is it always new information that you're getting from the State Police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding, and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for. And obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay. So if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury. But as far as receiving the minutes, yes, I'm aware of the dates. And when I received the minutes, then that would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records as far as what was requested, I would always have at least in some form, some sort of running list of items I was looking for. And then if I received an item, then that would be something that would be off the list. Now that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
And so you'd have whatever's on the list, you'd have emails requesting that information. Is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was. Maybe you were asking for 10 things and you got 5. You check those 5 things off your list. Is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the State Police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No.
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
You work for the DA's office, right?
I do.
And it's in the DA's office, right?
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is our witness.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did have portions of the file. I have access to the file, and I did review portions of the file.
Okay. So you did review portions of the file?
Yes. Oh, yes.
You just didn't review your checklist?
No.
Okay. Now, in terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but other items of discovery, video that they recovered, that there's a litany of different items.
A litany of different items?
Yes.
Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, start that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not. Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been phone call on some of those.
All right, so let's stop there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes.
You have individual notes?
Yes.
And where would those notes be right now?
In the file.
Okay. So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all the other entities and officers in State Police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature.
Okay. What happens when you ask for something, let's just say from the State Police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you ask for it before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date, vague questions about policy.
This is general practice, generally Mr. Lally's practice. And I think part of the issue here is we don't have very specific items that are being referred to. Right. But I think I'm going to overrule the objection and give Attorney Scapicchio a little bit of leeway here in terms of general practice.
So in general, how many times do you email for the same document before you go to the State Police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
Okay. So let me ask specific questions about this case. When you reached out, let's start with Trooper Proctor, in this case looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrant.
Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the King Gardner case?
In 2021 or beyond?
2000, let's start with 2021. How many search warrants? You guys have search warrants?
6.
6 search warrants. Did he, when you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrant?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
You did not?
I did not.
Okay. So did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Okay, so you got a portion of 2 search warrants, and you knew there were 6 search warrants, is that right?
Yes.
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants. You haven't given them to me yet?
I believe, yes.
Okay, those notes are in your file?
I believe so, yes.
Okay, and then when you didn't get search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all? Or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So how, then I guess I'm confused about how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrants?
Specific date, I don't know.
How long before the next time you asked him for a 6 search warrants?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the 3rd time? How much time went by?
I don't know.
Months or weeks?
I don't know.
What about the 4th time?
Again, I don't know how many times and I don't know specific dates.
So I guess my question is, how does your system work if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times? What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that in this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either I don't
Remember how you met about the search warrants the first time?
The,
In other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down.
Yes.
And you ask him for the 6 search warrants. And what does he say?
He will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
Well, give me a best estimate of what you said to Trooper Proctor after you asked 5 times the search warrants that he didn't turn over.
Sustained.
So did you keep any notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No.
Why not?
It was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
Objection, assuming facts.
Overruled.
I'm sorry, could you repeat the
Did
question?
you send another email to Trooper Proctor after you had this sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right, a few months.
Yes.
So February, March of 2022, is that what you think it is?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have him right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says, you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just want to give them to you?
That I don't know. You'd have to ask him.
Well, you don't get the search warrants in any event after that sit down, and you send another email. What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information he's not giving you, right?
Objection.
Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I'd say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Oh. Judge, can we press side by just briefly? I know.
Sure.
In any event, ADA Lally, a couple of months goes by, you still don't have the 6 search warrants. What do you do?
I don't know. I mean, I specific to the 6 search warrants, I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Okay. So I guess what I'm saying is you knew they existed, and you knew that, let me just say this, you knew that all 6 search warrants existed. Is that right?
Yes, we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. That's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that they were search warrants, how that material was obtained, and the material that was returned in response to 3 of the search warrants was marked as grand jury exhibits 33, 34, and 35.
Right, but not the search warrant.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that question.
and I'm trying to. So
Okay.
with regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials also that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right, so you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit, that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay, so you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
In 2021?
Correct.
Okay. So at some point when Mr. King is arraigned, you understand at that point Rule 14 kicks in, right?
Yes, I mean, I'm thinking,
right?
I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over.
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then remember at some point in December of 2021, receiving a discovery notice from me. Okay, what are you trying to?
Yes.
This is just my discovery notice.
Discovery motion, or what is
Motion,
that?
I'm sorry, motion, Judge.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I approach the witness, Your Honor?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge.
Do you know what it is?
I think it's,
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. But
All right,
I won't
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
And did you do that in this case? Did you send my motion for discovery to Trooper Proctor, to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email, or do you get in your car and drive down there and say, we got to end this, give me this stuff?
I email or a phone call.
Okay. And so did you email a phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response?
I don't
when you
recall.
asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the 6 search warrants?
I'm sure I did, amongst probably a number of other items.
Okay, and then you knew the case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I have these 6 search warrants that Trooper Proctor has, I can't get my hands on them, can you issue an order, or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay, but you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
I don't recall.
Well, don't you tell him, get me these things now. I'm coming down your office?
Objection. Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? What's the policy in the office of the district attorney's office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection. Overruled if there is a policy.
What's the policy?
I don't know any specific policy related to that.
Okay. So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection. Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery that the discovery request the counsel is speaking to, I don't believe it was ever docketed. I don't have a copy of it. I've never seen it. So
the motion. The motion.
The motion for discovery was filed. He got
it may not have reached the docket.
I want to make sure that you see it, though. Let's make sure
I'm speaking about it a lot here.
No.
I've never seen it.
Attorney Scapicchio, can you just give it to Mr. McGee for a second?
Sure. You think it would be in the file?
I would think it would be in the file. Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned and it's probably, I don't know if it's draft or not.
Oh, is it unsigned? All right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion before had it.
All right, we'll figure that out.
You guys,
We do have ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right out the docket.
Okay.
so,
And just so the record is clear, we have marked it? You want it marked as Exhibit 1 in this hearing?
yes, sir.
Sure.
All right.
Get you a signed copy, apparently.
All right, that will be Exhibit 1.
Thank you. I'd also, at some point, Judge, I'd like to mark the pretrial conference report in this case.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there was a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as saying I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Okay. So how much time goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, you got to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. Now, you talked about having meetings, discovery meetings. Tell us what those are.
At various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants were still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but.
So how many motions or how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
Not many. I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect the discussion?
So if there was something that specifically was known as far as, this is what's going on with this piece, and an anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrant? So you still don't have?
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, so let me ask the question. So when do you realize that you never turned over the search warrant? When do you realize that?
As far as the 2021?
Back up. When did you get the search warrant in your custody?
In my custody?
Yeah.
I would say probably I became aware of it About a month ago?
In 2025?
Yes.
July of 2025 or June of 2025?
Yes.
Is the first time you became aware that you didn't turn over the search warrant?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then when did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024?
Yes.
And how does the case, let me say in general, how does the case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay. So what did you do in this case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. Did you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Cooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding, then I would have got them and provided them. So no, I did not reference that specifically.
But then at some point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Did she say that to you?
No.
She never did?
Nope.
Did you ever have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection. Sustained.
Well, so when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. And then December.
That's why I want a date.
And October as well, when Your Honor set this for trial. Thank you.
So when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there were.
And do you remember, excuse me, do you remember the court asking about discovery and how the discovery was proceeding?
I'm sure it happened. I don't recall that specific date or what was asked.
Okay. And do you remember telling the court in January 2024 that you were hopeful that by March of 2024, we could proceed forward because discovery would be complete? Remember that?
I don't.
Okay. May I proceed, Mr.
Yes.
From when? That was
January 2024.
I know. Show you the request. Okay.
May I proceed, Mr.
Yes.
I'm going to give you the transcript of the appearance before this court on January 24, 2024, and ask you to look on page 5 and tell me, read that the bottom of page 5 to yourself and the top of page 6.
Yes.
Does that refresh your memory as to whether or not in January 2024 you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can we get them to us?
I didn't read that portion. I was reading the highlighted portion. If I could have a moment.
Sure.
Sorry, I'm not seeing what you're referring to in that.
Well, do you remember telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines 16, 17, and 18 on the document that's in front of you, Ms. Lally.
And what page, Mr.
Page 4, lines 16, 17, and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry, in the transcript that you handed me, I don't see that.
Let me see, it's a different one. Do you remember, hold on, let me get this right. Do you remember telling the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Proctor about, but I think hopefully that by March 11th date, we should be able to proceed forward. Do you remember saying that to the court?
Do I remember saying that to the court? No. If
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. What page are we on?
Yes.
You can read from here over to here. To yourself, please.
Sure. Yes, that's correct.
Does that refresh your memory? Maybe a rally that you indicated to the court that, yes, that's exactly right. There may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Proctor about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
Okay. But weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants.
Separate search warrants, yes.
And nothing's ringing a bell that you didn't turn over 6 search warrants?
Apparently not.
Okay. So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted. Is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants. Is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back, we suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date. So there may be a couple of other additional items of discovery that I need to get and turn over. But otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
Again, I don't.
Finish, Your Honor.
Yes. These transcripts in the FTR, what's on the FTR, what was said by whom, when, is all a matter of public record, and we can look at the FTR and get it. So specific quotes and what was said, what was represented, that's part of the record, and we can see
I just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay. Now, other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand, normally we file a pretrial conference report where you agree to give me what I'm asking for, and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't recall every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what in your mind was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Or there's been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay. And do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their file?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their file?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
An ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
No.
Okay.
And can you tell us, was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Okay. And is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time. That would have been it at the time, but now I would do that much, much earlier in a case.
Okay. And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as his honor just asked, no, I didn't.
Okay. So I guess my question is, how did it work? Did they only look through their file and send you what you're asking for? Or at any point did they send you, here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in the case.
Okay. So when you go in this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file. Is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police. Is that right?
Correct.
Okay. So when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files. It's on my list of things to do, but I never get down there. You should get down and take a look at the files.
Not that specific, but yes.
What did you tell her?
That, you know, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
Okay. So I still kind of understand. Is there like when the police give you something, do they just email it to you, or is there like a list to say, we gave A. Lally these documents on this date?
As far as their list?
Yes.
I have no idea what they have.
Okay. So you don't know, as you say today, if they have an index of all the things they say they gave to you?
I don't.
Okay. And do you, on the opposite side, have an index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here. I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you've received?
My general practice would be, yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapicchio, it's a little after 11, and we're going to be able to go until about 11:10. And then I have to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing. Okay. Attorney Lally, you can step down. Thank you. For the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21, CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Scapicchio.
It was on behalf of Ms. Garner.
I don't know. I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case. All right. Next dates. I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
might I ask also that the court order if they're materially prejudicial to the defendant as we explore this discovery?
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced?
Right,
these materials
right. It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed, okay? And
might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
Well, let's start in tranches. Okay, we can deal with April, and then we can deal with May.
Okay.
And if we have to deal with it in parts, we can deal with it in parts.
Sure, Your Honor.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel files a motion? Up until that point, I'm not going to.
Mr. McGee is suggesting that which of the documents produced as of the time you filed a motion for sanctions or to dismiss,
okay,
or do you now view as prejudicial? That is to say, and frankly, how you were prejudiced. Okay, this is a witness who's deceased, or we have no way of following up on this, or whatever it is. Okay.
That's only part of the other. I don't want to not meet before that.
Will be.
I mean,
I would like you to do a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And I'm happy to give you a date when we can continue this hearing.
Sure. How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
Could I bring the other parties in?
Sure.
Another ADA's draft.
Sure.
Parties. And I know we have counsel here for another party, so.
If somebody has the transcripts of all the various hearings.
I do, Judge. I'm happy to share them with everybody.
Yeah, share them with everybody, and let's.
We literally late last night.
All right, but my point is, in the next hearing, stand up and say Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1. Okay, and Exhibit 2 is our reconciliation between the documents, and this is the way in which they're different or new. Okay, and Exhibit 3 is whatever else you want. Here's our discovery report, and here's my discovery motion, and here's the motion. You don't need a witness for that. These are all part of the record, and there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But So I think this can be done in a much more streamlined way. And hopefully we can do it that way. How much more, what other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today, and I anticipate ADA Hickman. Those are the only three that I have subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Kelly.
All right, how many witnesses do you think you're going to need?
Trooper Tully here, Deputy Chief Collins, and Officer Benda, regarding the Milton issues. And there's a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman, being the predecessor counsel and now counsel of record on the case, that she can answer any questions the court can has that are remaining from right where she stands.
All right.
And opposing the production of.
All right, so we have 4, maybe 5 witnesses left. So we need a day when we can do this in an efficient way. Jim, how does our calendar look?
Well, 7/29, which is a Tuesday, is particularly good.
Particularly good.
Well,
there was a reason for that. I'm trying to remember what that reason was.
Tuesday.
We have a noon lobby conference.
There's a lobby
I have
conference.
a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
Hello, friends and family. So, I'm glad that we were able to re-watch that and kind of get an idea of what Lally's first hearing was like. So I will keep an eye out. It's 10:54 now. I will keep an eye out on the Zoom. I'll log in at like 1:45. And hey, clerk, how are ya? Stay safe. I'll log in at like 1:45 and see where they're at for if they come back at 3 or 2. If they come back at 2, it will just be going over what the paper, that chart that he sent them out to make, and then it will go over the 2 motions that they have filed. One is to like stop Lally and his to streamline his testimony because he doesn't apparently want to testify. And then of course Michael Proctor's phone. And I think that Michael Proctor also put in one to streamline what he testifies to. So we will see what happens with that. But I'm going to go for now. I have to call the school board in regards to Liam and his IEP. So I need to take care of that, and I need to call the school. And once I get that done, I'll be jumping on. So just you guys, if you want to just keep an eye out for a live. I'm not going to go live unless they are on. So if they're on, I will go live. All right. And then if they're not on, then I will. We just won't come on at all. So if they don't come on, then we'll see you guys tomorrow. Is there one tomorrow? What's the next one? No, Thursday. Sorry. We'll see you Thursday night. If I don't come back on today, we'll see you Thursday night when we have Bobby Sauce on. So, and then of course Saturday night we'll have Kids Club. This past Saturday I was stuck at St. Petersburg. I didn't get home till 9:30, so I couldn't do it. And Amy was crashed out. She had a busy day. So fingers crossed they come back on and we can see something at least. And then yes, Stacy, have a great trip. Maddie Mo, yo, what's up? I hope you enjoy your trip to Bermuda and enjoy your pedicure and know that we love you and to come back. You can't stay in Bermuda. It's not allowed. Okay? Cannot stay there. We need our Spacey Stacy. Yeah, we're at the end of the show. So they didn't even do court. Basically, he sent them down to work together on a chart because they were conflicting. And so they released all the witnesses. It was a 10-minute hearing. And they said they would be back at 2, possibly. So if they're done with the chart at 2, they're going to come back. And I'm going to check it. If the Zoom comes on, I'll go live. If the Zoom does not come on, I'm not going to go live. Other than that, they rescheduled all the witnesses' testimony until the 12th. But if they don't have paperwork going on, this stuff gone over today, then on the 12th, it will not be any witnesses. It won't be evidentiary. It will just be the motions until they get these motions figured out, and then they will schedule for evidentiary. So I'm hoping they go on today so they can at least get that stuff done. But it all depends on how far they get, because, blame it on the Commonwealth. Shocker, they didn't turn over discovery until some of it this morning. So how is Scapicchio supposed to do anything or keep anything in line if she's not getting the discovery until the morning of? So, and Judge Krupp was, compared to last, Maddie, I showed the last hearing again with from the 25th of July 21st hearing with Lally testifying. So we kind of got a new refreshed version of Lally testimony. And then what we'll do is we will see what happens. So keep an eye out for the live. And I love you guys. I'm going to go call the school board. So wish me luck. He was completely different, Clark, today. Krupp was the judge he was in the hearing with Lally last time to what he was today was completely different. So I fully believe he was told to protect the state and the system. I fully believe you. And, got a report. And Tully was there. So why was Tully there? Yeah, Jim was bright and early, and we got to see his forehead a lot, so that was fun. But Tully has no reason to be there, so why was he there? I don't get it. It makes no sense to me. So, but Proctor was in the building, from what Aiden said. He hadn't seen him, but he heard he was there, and then Lally was sitting diagonal from him, he said, in the courtroom. So we'll see. All right, guys. I love you guys. Mwah, mwah. I will see you later this afternoon. All right. Bye.
How am I supposed to say that? Talk time with Amy in Boston and Kelly. Time with Amy, Boston and Kelly. Talk 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 time with Amy, Boston and Kelly is a member, y'all. Is a member, y'all, to the Gene Deal Show. Talk time with Amy in Boston and Kelly. Talk time with Amy, Boston and Kelly. Talk time with Amy, Boston and Kelly is a member to the Gene Deal Show. Oh, thank you for your membership. Talk time with Amy and Boston and Kelly on the Gene.